Let's go on the record on cause number DC 203325, Troy Capital LLC versus Ramon Espinosa. Counsel, make your appearances.
Good morning, Your Honor. This is Jeff Hacker, and I represent Troy Capital.
And Trent Sims, I represent the defendant, Raymond Espinosa and Jorge Esparza.
Great. Let's go ahead and get started on this. The case is live on YouTube and we are on the record. Mr. Hacker, would you like to proceed with any pretrial matters before we get started?
No pretrial matters, Your Honor. I would like to call the court's attention to the business records affidavit, which was filed on
Give me 1 second. Give me 1 second. Let me deal with this. So are you offering that as an exhibit?
Yes.
Okay. Any objections at exhibit 1?
No objections, Your Honor.
Is that exhibit 1, Mr. Hacker?
That is exhibit plaintiff's 1, Your Honor. Yes, Your Honor.
Exhibit 1 without objection is admitted. All right.
Your Honor, this is a vehicle deficiency lawsuit. This particular case originated with the purchase of a 2015 Dodge automobile, which was on.
I apologize, Mr. Hacker. You're jumping ahead a little bit. Let me hear from Mr. Sims to see if he has any pretrial matters. Okay. Mr. Sims, do you have any pretrial matters?
No, Your Honor. I have no pretrial matters at this time.
All right, Mr. Hacker, you may begin with your opening statement.
Thank you, Your Honor. This is a car repossession case. It originated with a loan made on October 31st, 2015, financing a 2015 Dodge automobile. In about 3 months after, in March of 2016, the car went into default. The loan went into default. It was repossessed. The original creditor, which was Chrysler Capital, which is the private label of Santander Bank USA, repossessed the vehicle. In June of 2017, that loan was included in a parcel of loans sold to my client, Troy Capital. The particular case, as I say, involved a repossession of the car, which was done in accordance with the regulations. As part of the business record, you've got correspondence that was sent to the defendants advising them that the car had been repossessed and would be privately disposed of at some point. Subsequent to that, on April 28th of 2016, the car was sold. Within 30 days of that time, the plaintiff sent a explanation of all charges to the defendants, advising them of what money had come in, how it was dispersed, and what deficiency existed. As of the closing of the file at that point, after the repossession and allowing for all charges, there was a deficiency of $11,905.90. The contract provides that in the event it was necessary to go to court, that there was a provision allowing for attorney's fees. And in the business records, you also have an affidavit as to attorney's fees, claiming 10% attorney's fees, or $1,190.59 in attorney's fees. Basically, it's that simple. That's what we're asking for, and that's the evidence.
Mr. Sims, would you like to make an opening statement?
Yes, Your Honor. So the plaintiff has produced a business record affidavit and some documentation that they believe is enough that they are entitled to a judgment for the full balance of the debt. However, based off of the documentation provided by the plaintiff, defendant's stance is that the plaintiff has failed to prove up their damages for this case and therefore is not entitled to a judgment for the balance of the case. And the defendant would actually like to request a take-nothing judgment in favor of the defendant, given that the plaintiff has failed to prove up their case based off of the documentation provided to the court.
Okay. All right, let's go ahead and start the case in chief. Mr. Hacker, go ahead.
Case in chief, Your Honor, rests entirely on the business records affidavit, which has been submitted into evidence.
Okay. Have you emailed that to Ms. Rieger, my court reporter?
Sorry?
Have you emailed that to Ms. Rieger, my court reporter, pursuant to the emergency law?
I believe she should have got it from, I'm appearance counsel, so I believe it should have been sent to her, yes.
Ms. Rieger, do you know if you have it?
No, so I'll have to check. Approximately when would it have been sent?
I would have assumed it would have been sent last week. Give me your email and I'll resend it to you. I have a copy of it here.
Great. Tony, do you want to put that in the chat?
Okay.
And I assume you sent this to Mr. Sims as well, correct?
He's got a copy of everything, yes, Your Honor.
Okay, do you see that?
Yes, Tara Rieger.
All right, let us know when you're ready, Mr. Hacker, to begin.
That's all that I have, Your Honor, and I am forwarding it in right now.
Okay, Mr. Sims, go ahead. So do you rest, Mr. Hacker?
I rest.
Mr. Sims, call your first witness.
Your Honor, I will have no witnesses today. All of our arguments will be based off of the documentation and the business record affidavit that the plaintiff has presented as well. The documentation that we received from the opposing counsel is 82 pages in total.
Okay.
I
You'll
guess
do that during closing. So if you don't have any evidence, you're not submitting any evidence at this point.
Correct. No evidence, just
So you rest.
correct.
All right. So let's do closing arguments. Mr. Hacker, did you want to make a closing argument?
I think it's the evidence is the business records. It shows that this is a legitimate and correct debt. And that there is enough to substantiate how the plaintiff acquired the debt. And that everything was properly handled in accordance with the laws. And we ask for a judgment for the deficiency and the fees.
All right, Mr. Sims, you said there was a defect somehow in what was submitted. Do you want to go ahead and share screen and show me what that is?
I do not have the ability to share screen given that I'm on my phone.
Mr. Hacker, can you share screen so that we can?
I actually have it showing up on another computer next to me. And I don't, honestly, I don't know how to do that. But
Why don't you do this? It might be easiest. Why don't you email me as well as the other side, and so I can have a copy and I'll share screen for you. I'm going to turn YouTube off because I don't want